Today we are joining nationally board certified elder law attorney Tim Crawford in a conversation with Samantha. They will be discussing the various areas of planning that one may wish to consider. Attorney Tim Crawford is a board certified expert as well as a tax attorney and CPA. Tim has been assisting families with their planning needs for over 40 years.
Tim, I understand there are many different areas or levels of planning that one can do. Can you describe some of those to me?
Sure. One of the most important is to start out is to be prepared to be mentally incompetent. You need to have some documents ahead of time to accomplish that goal. And the first document we encourage everybody to have is a health care power of attorney, a document where you select somebody you love to make medical decisions for you when you are unable to make those decisions for yourself. And then a next document is a financial power of attorney. We encourage you to fill out one at the bank on your checking and savings account, authorizing your daughter or son to make withdrawals and write checks, as well as to have one prepared by an attorney which can run your entire financial affairs. And we call that a level 3 planning type financial power of attorney. And then there's a third document in this area that's very helpful, and that is an authorization to do planning document, so that your loved one can actually go beyond running your financial affairs and actually do planning for you at the time you are incompetent and possibly in a nursing home, and you can't do planning yourself, and you're going to be trying to reduce your assets so you don't have to spend them on nursing home care. So we call that an authorization to do planning document.
Okay, thank you. I have a will in place, and I'm wondering if that document alone is enough so that I'm prepared for when I die for things to be taken over by my personal representative or loved one.
Well, there we encourage you to go beyond the will. The will is a wonderful document, but you want to get beyond the will so that you can skip over probate court at the time of your death. Probate court is the process of getting assets retitled, usually from the widow over to the children. She has assets registered in her name alone, and those are the ones that have to go through probate court to get retitled. So the goal is to try to figure out how can we skip over probate court and get the assets distributed like you would want to do at your death, but without having to have the probate court involved in doing the retitling process themselves.
Okay, I've heard things about like a living trust. When is that appropriate for people?
Okay, that is one of the things we look at when we're doing planning to be prepared to die. We want you to be in a situation where death does not cause problems for your family. Again, probate is going to take your family 50 to 100 hours worth of work. They'll have several meetings with a probate attorney and with the probate court judge. We know we generally don't have that when the husband dies because they have planned to avoid probate using joint tenancy and beneficiary designations. But when the widow dies, we have some assets that are beneficiary designated and others aren't. So again, we're looking for that way to avoid probate. And you mentioned the term living trust. Living trust is an excellent way to avoid probate. And sometimes you will use a living trust, and sometimes you will use simpler, less expensive probate avoidance packages.
Can you tell me the difference between the two?
Sure. A living trust is a document like a will where you're going to specify who gets your money and when they get it. The advantage of the living trust is it can have assets titled to the living trust, and therefore those are no longer probate assets. They're no longer in your name, and so they can be retitled that way. We'll use the living trust when we want to accomplish other goals. Maybe the additional goal, in addition to avoiding probate, is a goal to hold back money from young people. So if your children are 10, 15, 20, or even 20, 25, 30, you may say, when we both die, we don't want that child to have that money immediately. They may spend it foolishly, so we want to hold it back and dole it out to them slowly. That's a purpose for a trust, in addition to the probate avoidance. Also, it could be designed to minimize death taxes. When a couple does a trust, we can minimize death tax expenses, so that's useful. So holding back money, minimizing taxes, and avoiding probate. But now we compare it to other choices. Well, maybe we don't have a death tax problem, because for most people, this year, which is 2012, they can leave $5 million to their children without a problem. Next year, that is scheduled to go to $1 million. But 99% of the clients we work with have less than $1 million, so they can leave their assets to their children. They don't need any fancy planning to avoid death taxes, so they don't need the trust for that reason. And they have kids that are in their 30s and 40s, and they say these kids can have their money outright immediately when we're both dead, so they don't need to hold back money. So they can be looking at a less expensive package, which only focuses on probate avoidance. And we do that for many families each and every year. And that's something that's only been around for the last 4 years. So if you've had an estate plan previously and you did a will because you thought going to a trust was so expensive, now for basically the cost of doing a will, you can be in a situation where you use a probate avoidance package to get the assets from the widow to the children. And the ideal time to be doing your probate avoidance is while you're still a couple. There's wonderful documents we can use in addition to a probate avoidance package to eliminate the need for probate.
Okay, what if I'm starting to get a little bit older and my concerns become having somebody come into the home and provide care for me there, or if I need to go into an assisted living facility or perhaps even a nursing home?
Well, that's a very important problem that most people don't think about until they're actually in the facility or until they actually need some form of long-term care. Like you said, it could be bringing somebody into your home to keep you out of a nursing home. It could be taking the next step, usually when you're widowed, to say, oh my goodness, I don't want this big house anymore and I want to move into assisted living. Or it could be care in the nursing home because the doctor ordered you from the hospital to the nursing home. So those have a very high cost, and I'd just like to review those costs with you for a moment because it will bring to your attention the need to do planning in this area. And the average cost for being in a nursing home right now is around $100,000 a year. I know that's shocking to many people, but it's a very labor-intensive process, and as a result, it's very expensive. Even going to assisted living can be $30,000 to $50,000 a year, and to bring somebody into your home might be $20,000 to $50,000 a year. So you look at that and you say, wow, that's high cost. How am I going to pay for that? And the next thing that you look at is you say, okay, well, what are the odds that I'm going to need long-term care? And the answer to that is 60% of the time before you die, you will need some form of long-term care. Now, many times it's just care in your own home, or maybe you move into your daughter's house and she takes care of you. But many times it gets more expensive because you move beyond the family helping you to bring paid people into your home. Or you go to assisted living, or the doctor orders you into the nursing home. So that care is very expensive, and we encourage people to do planning in advance to reduce what they have to pay for that care.
If I own a home and say I can't stay in that home, or even if I can stay in the home, I understand that I can still get some assistance from the government in helping to pay for my care. Is that true?
Yeah, that is true, but there's a big problem with that. It's not just getting the government to pay for your care that's the problem. It's trying to protect the home so that at the time of your death, the government doesn't force the sale of the home and thus you lose it. You didn't protect it. So a common misconception is because I can apply for government benefits to pay for my stay in long-term care, people automatically assume that the home is then protected. That's the biggest misconception out there. You can have a home, apply for benefits, but you should think of that as a loan from the government, and they actually put a lien on your house. And when they do that, you're not going to be doing any more planning to protect that home. So the ideal time to protect a home is while you are not yet in a facility